giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
Between the dates of July 2nd, 2022 and August 2nd, 2022, the location of 3749 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, were you an employee of Target?
Yes, Your Honor.
What'd you do that makes you think that you're guilty?
I forgot to pay for items I ate while I was on shift, and I also set aside items that I forgot to pay for and left the store without paying for them.
Okay. So you're saying you forgot to pay for them. You're
Yes.
saying that you didn't leave the store or do those things intentionally?
No, Your Honor.
That's not what you're saying, or no, you did not do it intentionally?
No, I didn't do it intentionally.
Well, you got a problem. I can't accept that plea.
Buckle up, guys. Today we're going to witness a plea deal almost fall apart in real time. A 19-year-old Target employee admits she took items, but insists she didn't do it intentionally. That one word changes everything. The judge stops the process cold and says he can't accept the plea in that instant. The courtroom shifts from routine procedure to high-stakes tension, where a single clarification could determine her entire future.
Your Honor, I believe that she would admit that she did leave the store with the items and take them in her possession without paying. And her intention was to pay for them at extra time.
I heard her say that, but she didn't remove those items intentionally. I mean, we don't prosecute people for what are claiming to be mistakes.
I think she did intentionally remove them. Her plan was to pay for them at a later time, which would still constitute intentionally.
That's not what she said to me, Miss Reed.
Your Honor, if I could ask her a few questions.
Certainly.
Ms. Hawkins, did you make a statement to the officers that day?
Yes.
And do you remember telling the officers that you took the clothing with the intention of paying for them on a later date?
Yes.
And so when you removed the items, you had not paid for them?
No, Your Honor.
Did you pay for them at some point?
No.
I guess then the next thing would have been, would you have had the opportunity to be able to have paid for them at that later date?
What do you mean? What do you mean by that?
Okay. If I'm trying to look to pay, say based upon my paycheck. So I got my paycheck is a week out. And so I take the items out of the store and I'm going to pay for them that next paycheck. But come that next paycheck, I don't pay for them. And I know I'm not paying for them. Is that what happened in this case? Or did you not have an opportunity to pay for the items?
Yes, that's what happened.
What happened? You just didn't pay for them?
Yes.
As the questioning continues, the prosecutor methodically walks her through the facts. She acknowledges taking the items, knowing she hadn't paid, and never returning to settle the balance. The judge presses for clarity, making sure intent is unmistakable. What began as, "I forgot," slowly turns into a firm admission. You can feel the legal trap closing as her own answers solidify the case against her.
Okay. So just so that we're all correct, Ms. Hawkins, you took these items out of the store knowing you had not paid for them?
Yes, Your Honor.
At the time, you may have thought I was going to pay for them, right?
Yes, Your Honor.
At no point did you go back and pay for them. At some point, you just made the decision that you weren't paying for them. Is that correct?
Yes, Your Honor.
All right. And the property that you took out belonged to Target. Is that correct?
Yes, Your Honor.
All right. You didn't have anybody's permission to do that, did you?
No.
And you came into possession of that property by virtue of your employment with Target,
Yes.
correct? And the amount of property that you took out was in excess of $200?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is also satisfied.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be June 14th, 2023, 9 a.m. as your Zoom invite indicates. Young lady,
Yes.
why
Your
didn't you go back and pay for these items? Out of curiosity.
I guess I was just waiting, and then I just waited until I was still waiting, and by the time that they had talked to me about it, it just been too late to pay for them at that time.
How old are you?
19.
Are you in school?
Yes, Your Honor.
Where?
University of Michigan.
Are you originally from around here?
Yes, Your Honor.
Your parents are in the area?
Yes, Your Honor.
They know about this?
Yes, Your Honor.
What'd they say?
They were very disappointed.
Well, I know how they felt. What'd they say to you?
They said that I should just be honest and that I should explain what happened.
Young lady, why'd you do this?
Because I just I just thought that I was gonna get away with I guess not paying for certain things because I was there, and that even though I was planning to go back and pay for them, that the rules just I guess didn't apply to me because I worked there, and I took advantage of that.
Something tells me you were probably raised better than that.
Yes, Your Honor.
What year are you in school?
I'm a rising sophomore.
Did you ever think about what this would do to your future?
Yes, Your Honor.
The tone shifts when the judge asks her why she did it. She admits she thought she could get away with it because she worked there. That honesty changes the atmosphere completely. The judge suggests she was raised better than that, highlighting the gap between her potential and her decision. It's no longer just about stolen merchandise. It's about character, choices, and a young future hanging in the balance.
Kind of stupid, isn't it?
Yes, Your Honor.
If you really had needed that stuff, you could have gone to your mom and dad and they would have found a way to get it to you. I just had that feeling. Isn't that right?
Yes, Your Honor.
What are you going to be when you grow up?
I want to be a neurosurgeon.
Dear God. You're that smart?
Yes, Your Honor.
Okay, let me give you a bit of advice. Stick to all of the things that are involved in neuroscience. Stay out of criminal activity because you don't do it well, because you're not a criminal. You weren't raised to be one. You don't think like one. That's why you got caught. We understood?
Yes, Your Honor.
I ain't gonna make her too mad. I may need one of those soon. I don't know. I don't even know what they do. But all right. We'll see you on the 14th, young lady.
Thank you.
Stay right there, and we're gonna put you into a breakout room with probation to exchange information.
Okay. Thank you, Your Honor.
Thank you. Court calls the case versus Sean Caldwell.
Good morning, Your Honor. Christopher Shemke appearing on behalf of my client, consenting to the matter being heard via Zoom.
Jessica Blanche appearing on behalf of people.
And good morning, Your Honor. Rita Young, P44626, also appearing on behalf of Mr. Sean Caldwell, who is present by Zoom. Mr. Caldwell, could you state your full name for the judge, please?
Did he state his name? I'm sorry, I didn't hear.
Yes, I'm Sean Caldwell. I'm sorry, I didn't.
Okay, now here. Thank you, sir. All right, what are we doing on his cases?
Judge, as to my
No.
case, oh, go ahead, Mr.
I'm sorry.
Shimke.
On my case, Judge, the 23 FB 1202 FY, I am now in receipt of full discovery. I would like to have a 1-week adjournment on that case so I could meet with my client. I'm also representing him on another misdemeanor case that I'd like to review with him. So I'm asking for a 1-week adjournment.
And Your Honor, as to my case, I would ask that it be rescheduled for an in-person preliminary examination, please.
Can I actually, Your Honor, real quick, can I not have this lawyer anymore? She actually left me hanging and didn't answer me and left me up running around. It's probably the reason I'm in this mess right now.
Are you referring to me, Mr. Caldwell?
Yes, 100%.
Sir,
So Miss Young is the reason you're in this mess?
Yes,
I don't think so. I'm just thinking, I don't think she was there. She's not listed as a witness. But
Judge,
go ahead.
just for the record, I was appointed to represent him on January 9th of 2023. I got discovery on January 10th of 2023. I visited him at the jail on January 11th of 2023. We held the probable cause conference on January 12th of 2023, and it was set for a preliminary examination on January 24th. And unfortunately, Mr. Caldwell failed to appear, and a capias was issued. And that is why I am appearing now today.
Oh, well, that really sounds like you left him hanging.
If that's the way that it is.
Sounds like you were the one that didn't show up for the date, Mr. Caldwell. All right, so
I was there. The other person.
here's what I'm going to do.
What?
Here's what I'm going to do. Mr. Caldwell,
Yeah.
I think you got to stop blaming people for what happened. You didn't appear, and now all of a sudden you're here. You got another case that Mr. Shemke's representing you on, and representing you on that. I suggest that you probably not cast aspersions at Miss Young, who can probably help you out and was, I'm sure, here ready to go.
Actually, Your Honor, at this time, I would move to withdraw and ask the court in Mr. Caldwell's best interest to assign my case to Mr. Christopher Shimke so that they can be handled together, please.
Here we go.
That motion is denied. I'll take it in writing. I'm not going to do that. I'm not going to have somebody come in to make disparaging remarks so they can try to pick the attorney that they want. Both of you are fine attorneys. You guys can work well together. Sometimes if they just be quiet and just listen to what you guys have to say, you're good. But I guess he's leaving. Okay. So he just didn't want to stick around for it all. So, Mr. Shemke, you want what, a week out?
That's all I need, Judge. I will do an in-person meeting and then reach out to Ms. Blanche so we have an informed decision by our next court date. Yes, please.
All right, I'll adjourn your probable cause out a week. We'll see if we can get him to stay in the room. At 9. And then you wanted a preliminary examination, Ms. Young. So I'll set your preliminary examination in that matter for the 13th, 2023 at 9 that'd be before Judge Washington. That ought to be fun. All right, before Judge Washington. And what we'll do is we'll have his bond continued. That way he'll be there.
And Judge, which case, it was it the 1202 one that you're
Yeah, the 1202
Okay.
is being adjourned out 1 week. That's Mr. Shemke's case.
Okay.
And then in the other matter, we're setting it for exam.
Okay, sounds good. Thank you.
Thank you, Your Honor.
And Mr. Shemke, I'm sure you can talk to him about leaving the room before the court's done, but I'll let you deal with that.
Understood. Will do. Thank you, Judge.
In a sharp contrast, the next defendant blames his attorney for his situation. The attorney calmly details every meeting, every filing, and reveals he failed to appear in court, triggering a warrant. The judge shuts down the blame game instantly, refusing to let him attack counsel to manipulate representation. When the defendant abruptly leaves a Zoom hearing, it seals a moment